So good morning, good afternoon, and good evening to everyone. I hope you are well wherever you're joining us from. Before I introduce myself, I'd like to let you know that we have simultaneous interpretation into French, Portuguese, and Spanish. Please click on the globe icon at the lower part of your Zoom window and select your preferred language. Thank you very much. My name is Sharon Kiburi. I'm a multimedia data journalist and the East Africa Regional Lead Network for the Africa-China Reporting Project. It is my utmost pleasure to welcome you all to this webinar on breaking new ground, insights and stories on the impact of land corruption on discriminated groups in Africa. This webinar is a partnership between Transparent International and the Land Portal Foundation. Across the world, corruption is a barrier that prevents many people from accessing the land and resources essential for survival. Disadvantaged group and marginalized group communities often bear the brunt of these unjust practices. Compounding these discriminations, whether based on disability, ethnicity, gender, religion, further denies these communities the right to access land. In a groundbreaking research conducted by Transparency International and the Equal Rights Trust, the ways in which corruption and discrimination converge to erode land rights have been documented in 7 countries. This webinar will unpack these findings through vivid stories from across the continent. Our speakers today will share compelling examples such as how corruption disrupts land equity programs in South Africa, programs intended to redress long-standing wealth disparities. We will also hear about the exacerbation of historical injustices faced by Kenyan Nubian communities due to corrupt practices. Furthermore, our panelists will discuss effective responses. We will explore strategies that government and civil societies can employ to counter these challenges, focusing on policies and campaigns that enhance accountability and promote transparency in land governance, including how access to information and data can reduce corruption against vulnerable communities. Before I go on, I have to share a few logistics about this webinar. This webinar is being streamed live on multiple platforms. Please note that the live tweeting is occurring for this event from the Land Portal Twitter account, and the hashtag we're using today is land corruption, hashtag land corruption. So you can please join us on Twitter and engage with us on those platforms. We have also created a social media kit for this event, which has been shared with you in the chat. If you have questions throughout this session, and we do hope you do, please share. Please post them on the Q&A button at the bottom of your screen. We will attempt to answer as many questions as possible later in the webinar. Today's session is also being recorded, and you will receive the link to the video afterwards. Finally, an article with the key messages will be available at the Land Portal. Now, please allow me to introduce our speakers today. I'm joined by a terrific panel to discuss these interesting issues today. Our first panel is Sam Burns. He's the head of research at the Equal Rights Trust. He leads on the development of trust and research publication and was part of the 3 members drafting team that produced Protecting Minority Rights, produced a report on protecting minority rights, a practical guide to developing comprehensive anti-discrimination legislation, which was published in partnership with the Office of the United Nations High Commission for Human Rights in 2023. Barbara Godispoti is a global land program lead for the Oxfam Novib. Melusi Nkala is a senior researcher at Corruption Watch South Africa. He is the current acting lead coordinator for the Stakeholder Relations Campaign team. He has also been project manager of the Land Corruption in Africa project since its inception. Naomi Kabanda is the acting director of land management in Ministry of Land, Housing and Urban Development of the government of Uganda, where she has worked for the last 25 years. She has also been an expert on the team that developed Uganda National Land Policy, which has been under implementation since 2013 and is currently under review. She's also authored and researched spheres, chaired and many reforms of land sector, key among them, women rights through insurance certification, customary ownership, where women have been included in certification, drafting land acquisition policies, and now cabinet for approval and reforming land acquisition, laws including international principles and transparency accountability. So we'll start this conversation with Sam. So Sam, let me start this discussion with you. Can you please share some of the findings of the report, this beautiful land, corruption, discrimination, and land rights in sub-Saharan Africa?
Absolutely, thank you. I'm just going to share my screen, so please shout if it doesn't work.
Okay, please go ahead.
Can you see a very nice image prepared by the designer of the report?
Yes, it's visible. Thank you very much.
Brilliant, thank you. Then I will start my own stopwatch because otherwise I will speak endlessly. Thank you very much for the introduction. My name's Sam Barnes and I'm the Head of Research at the Equal Rights Trust. And today I'll be walking you through our recent co-publication with Transparency International, which is called This Beautiful Land, Exploring Corruption, Discrimination and Land Rights in Sub-Saharan Africa. So I'll talk you through the basic structure of the report, what it is that we set out to do. But first, I'm going to begin with a story. So this isn't my story. This is a story that was collected by Transparency International Kenya. And it concerns a woman called Faiza. In a sunny coastal village located in Kenya's Kilifi County, Faiza spent her childhood shaded by the palm and mango trees of her father's 4-acre estate. When her father passed away, Faiza's sibling took a loan from a neighbor, which remained unpaid at the time of his death. Faiza and her late brother's widow decided to settle the matter by paying the outstanding debt in a process that was mediated by the local village chief. But the issue wasn't resolved. Shortly after the money was paid, people began to trespass on Faiza's land. Faiza was convinced that the family who provided the loan had colluded with the village chief to obtain the legal title. In the coming months and years, Faiza saw her land parceled up and sold off to developers for the construction of new housing. Unable to afford the costs of a protracted court battle, Faiza's 6 children were pulled out of school and forced to shelter in temporary accommodation erected at the edge of her uncle's estate. Landless, impoverished, and denied the means to obtain a decent standard of living, Faiza and her family face a bleak existence, sustained only through the sale of palm wine that barely covers the basic cost of food. With her father and brother gone, so too is the beautiful land of Faiza's past. Her future, and that of her children, is uncertain. This injustice happened because we are women, because we are widows. If my father and brother were alive, things would have been different. Now, Faiza's story isn't unique. Across the globe, discrimination and corruption are conspiring to deny people access to the land and resources they rely upon for their survival. In 2021, we co-published Defying Exclusion, Stories and Insights on the Links Between Discrimination and Corruption. That report was the first step in a long process to explore the phenomena we termed discriminatory corruption. It was an initial publication, it was exploratory research, and it recognized the need for further research in this area. In this report, we take up the call for action. We examine the links between corruption and discrimination in the context of land governance in sub-Saharan Africa, and in a continent that's been scarred by the legacies of conflict and colonization. Discrimination and corruption in this region cast wide shadows, and their impacts are especially pronounced. The report is set out over 7 chapters. The first 3 chapters provide a broad overview. Sorry, Neil.
We can hear the Spanish and the English channel. Sorry.
No problem. So in the first few chapters of the report, we provide a broad overview. We talk about the report methodology, the ways in which we collected information. This was a primarily qualitative research report. It involved interviews with national stakeholders in each of the 7 countries under review. It involved community-level interviews and desk-based research. We go on in chapter 2 to talk about some of the main concepts that are under discussion. So what is land tenure? What is corruption? What is discrimination? Each of these, their own fields of practice. And then we go on to talk about the evolution of understanding of land under international law, building in particular on the recent general comment issued by the Committee on Economic, Social and Cultural Rights. In chapters 4 and 5, we get into the bulk of the research. So in chapter 4, we try to paint a global picture of discrimination and corruption issues in relation to land. We talk about this within the context of a global land crisis, some of the drivers of both discrimination and corruption, and the ways in which these different concepts interlink. At the international level, there's been fairly little consideration of their interactions, and that's mirrored in chapter 4. where we tend to treat both topics separately. In chapter 5, we go on to apply these learnings within the national context, and this is where we really get into the bulk of the research. So this is where we talk about the particular issues in each of the countries under review. We provide a general overview of the governing legal framework, the framework relating to land, and we talk about individuals' experiences, their knowledge of discrimination and corruption. And at the end of each one of those subsections, each one of the country sections, there's a case study that's been prepared by a Transparency International chapter that looks at the links between corruption and discrimination in greater detail. Chapter 6 is really where we begin to pull all of this work together. This is where we explore the dynamics of discriminatory corruption in greater detail. And then in chapter 7, we set out our overarching recommendations. So expanding upon the findings of our Defying Exclusion report, the testimony builds compelling evidence of a direct causal relationship between land corruption and discrimination. This relationship can be seen to manifest in 5 overlapping and mutually reinforcing ways. So the first dynamic we explore is that discrimination can result in greater exposure to corruption. The relatively weaker position of disadvantaged groups in society means they are at an increased risk and increased exposure to corruption. This is particularly true when aspects of a person's identity are stigmatized, stereotyped, or criminalized. And there's multiple examples of this dynamic throughout the report. Examples of women, persons with disabilities, older persons, and other disadvantaged groups who are viewed as soft targets for dispossession. Because many of these groups face greater barriers accessing justice, a corrupt actor is less likely to be detected. Even if their corrupt behavior comes to light, they may have less to fear than if they only targeted individuals from disadvantaged backgrounds. Discrimination can facilitate corruption as it incentivizes corrupt behavior on the part of perpetrators to exploit the less powerful while eroding the ordinary constraints on such action. And there's a great example of this in the Madagascar case study. That case study looks at the situation of persons with albinism. In Madagascar, there's been increased attacks against persons with albinism linked to harmful stereotypes, superstitions, etc. And in that chapter, individuals talk about the difficulties they face in achieving justice because of the fear that violence entails. And the UN independent expert on the rights of persons with albinism links this to a process of dehumanization. This is an extreme version of what we're talking about with this dynamic. Excluded from justice mechanisms and denied effective redress and support, discrimination means that individuals may be required to pay to access rights that should already be available to them under the law. Corruption in this sense serves a dual function. It increases the risk of land rights violation on the one hand, and it also facilitates the removal of barriers to entry for groups whose rights would otherwise go unobserved. And there's some very interesting implications of this analysis, I think, particularly in the context of justice and accountability mechanisms, which hopefully we'll be able to explore further later on today. So dynamic 2, some acts of corruption are directly discriminatory. So I've just provided one particular example there, individuals being targeted on the basis of their protected status. There's a good example of this from Kenya, which explores the situation of the Nubian community, who are subject to a discriminatory nationality vetting process and are often required to pay bribes in order to access identity documents. So what we're talking about here is where individuals are being targeted on the basis of their protected characteristic. They're being treated differently, they're being treated unfavorably. And there is a direct link there to the corrupt act or practice. Third, the impacts of corruption are often felt disproportionately. So in some cases, there's a direct link between a corrupt act or practice and the disadvantage experienced by a community. This is basically the distinction between direct and indirect discrimination. So not everything is specifically about targeting members of a particular community, but corruption can have long-term impacts, disproportionate impacts on members of particular minority communities. And we give a couple of examples here in this slide. Religious minorities who face losing access to sites of religious importance as a result of development projects, the youth of Zimbabwe who sit on housing wait lists and risk losing a generational right of access to land due to corruption in rural land governance. The impacts of corruption are felt hardest by communities on the fringes. And this is a really important point because I think quite often when we discuss these types of issues, this aspect tends to be relegated. It tends to be seen as less severe, less important. In fact, many of the issues affecting Indigenous peoples and other communities, they're all examples of this dynamic. Number 4, both discrimination and corruption can result in the denial of justice. We'll come on to talk about this hopefully later on today, but this is quite straightforward. Discrimination can prevent individuals who've experienced corruption from achieving justice, and the inverse is also true. And there's a good case study from Ghana which talks about perceptions of corruptions in justice mechanisms and the ways in which that has contributed to the situation involving the Fulani herders. Number 5, corruption impedes the effectiveness of positive equality measures. So where measures are designed to alleviate or address structural inequalities in society, corruption can directly impact the effectiveness of these measures. And I know Malusi will come on to talk about this in further detail. There's also a bit of this discussion in the Zambia case study based on evidence collected by the Environmental Investigation Agency, which looked at a particular scheme that was designed to boost the housing prospects of persons with disabilities. Now, each of these dynamics overlaps. They're mutually reinforcing. None of them can be siphoned off into sort of hermetically sealed categories. They're constantly at play. And you can see this through this image here. We're talking about issues of grand corruption, petty corruption, corruption in all different stages of land governance, land administration, management, and multiple forms, multiple grounds of discrimination. So if you think back to the very first of those dynamics, we're talking about systemic inequalities that eventually leads to discrimination and to corruption. Individuals denied access to redress, denied access to effective remedies, and then corruption can also prevent equality measures from reaching their intended targets, from achieving what they set out to do. That closes the loop. So this is how we conceive of the nature of this relationship. In the final section of the report, we set out our key recommendations. Again, I won't touch on these now. I hope we'll have the chance to talk about them in more detail as we go throughout the rest of this, this conversation. But we've separated each of them into separate headings. So recognition, protection, participation, accountability, promotion, sensitization, collaboration, and research. These are the different principles which we've directed our recommendations under. I've already spoken for more time than I should, so I'm going to leave things there. But thank you very much, and thank you everyone for joining us today.
All right, thank you, Sam, for that great presentation on this report. Let me now turn to our other panelists of the day to give their perspective. Let me start with Barbara. Barbara, can you talk to us about how the issues and trends outlined in this report are relevant at a global level?
Yeah, thank you very much, Sharon, and thanks Transparency International and the author for inviting me to be part of this webinar, and also the people here that have registered and shown up. I think that the way in which this report presents the nexus between corruption, discrimination, and land governance is absolutely relevant to the current global narrative on land. The report has the merit of outlining the issues and proposing recommendations that are not within a narrow vision of corruption and discrimination as confined to a specific system or to specific groups or to individuals. It shows the interconnection of these phenomena with, for instance, the historical legacy of colonialism, but also the interference of neoliberal economic models in the agrarian systems. It describes very well, as Sam also presented, the corruption and discrimination in specific cases, but it zooms out. I invite you, I don't have time, of course, to go through the reports, but to look, for instance, at the paragraph of the chapter on the global drivers of land inequality, which definitely play a determinant role in discriminatory corruption. I think that a risk of a narrow vision of corruption and discrimination as endogenous phenomena is very dangerous. Sometimes we see this happening in international debates around corruption, because it can divert the attention from global systemic causes, and even more dangerously, it can contribute to justify them. So in this sense, the report presents very bold and interesting messages. I'm Italian, so I always tend to look at the original meaning of terms, and I looked at the etymological sense of corruption, but also of discrimination. Corruption comes from a Latin verb, which is cum rompere, that literally means to break. So intended as degeneration, destruction, altering in a negative sense. And discrimination comes from a Latin verb that means to divide. So if you look at that, and from a global land systemic perspective, there are forces that actually are interfering, are breaking the integrity of a system. Not just in moral terms. They are breaking the integrity, for instance, of functioning and correct functioning local land governance systems. And these interferences are coming, for instance, from overriding economic models and interests. And sometimes it happens intentionally, either with bad intentions, but sometimes also with good intentions, for instance, to increase food production, to fix a system. So this can create unintentional conditions for increasing corruption, which then in turn multiply the predatory attitudes versus discriminated and disempowered groups. They also contribute to break social contracts, for instance, between the state and the citizens, but also breaking the social fabric within traditional and customary systems. So this is my point from a global perspective. Thank you.
All right, thank you so much, Barbara, for painting the picture on the global perspective, and also just emphasizing the need for broadening the definition of corruption to be more inclusive. Let me now turn to our colleagues in Africa to get their perspective on the ground. Melusi, can you give us an example of how corruption has impacted discriminated groups working in land in South Africa?
Thank you, Cherry, and thank you to everybody who's joining us for this historical event. I think it's quite fitting that Barbara, gave the etymology of corruption when you think about the words or origins, because particularly in the South African context and other countries across Africa, there's been a breakdown of cultures. There's been a breakdown of indigenous and local people's ownership of land. And in South Africa, this is probably the biggest economic crime to be committed, people being dispossessed and displaced from their land. And it's not something that only happened pre-94. It's been going on for many centuries. So, and the kind of principles by which this was done was on racial grounds, but also primogeniture principles to say that only men or males have the divine right to own land, which was a Western concept that was readily adopted in policy and in law in South Africa. And what the South African government then sought to do post-94 was to redress these issues, to say that, we're going to have policies that are going to address the land question, given the discrimination that people of color had experienced over the centuries. And so one of the policies that we looked at within this research relates to farm worker equity schemes. There have been several policies of this nature, and what they are fundamentally based on, or were based on, was the willing buyer, willing seller principle, which is simply to say that if we can find white owners of land as the state who are willing to sell their land to people who have claimed that piece of land, we will then assist those groups to purchase it. But what happened with farm worker equity schemes was for the government to say that we want farm workers to buy into farming businesses with commercial farmers. So if you're a commercial farmer and you have an interest, we will actually purchase a stake, shares for farm workers to work with you, but you have to then also provide an amount to this cause. Unfortunately, these equity schemes were not constituted properly. There was some nefarious activity by officials within the relevant department dealing with land issues from inception, and farm workers were discriminated against and experienced issues of accounting irregularities. They weren't paid their dividends in most of the instances. And those who were paid dividends in some of these businesses, these were infrequent. But moreover, there were issues of human rights violations. There weren't proper housing structures. They didn't have access to medical facilities or healthcare. And some of their children were not being given education or couldn't access educational facilities that are provided by the state. So when you think of that as a sum total of the experience of this particular group, then you actually understand how corruption and abuse or discrimination has impacted a marginalized group within South Africa. And it's not only unique to this group. Unfortunately for us, we were able to look at this group, but it's a phenomenon that is experienced widely.
Right. Thank you so much, Melusi, for that important insight. I would like now to get into the government perspective on these issues. Naomi, how does the Ugandan government currently look at and address issues of corruption in the land sector? How big of an issue is land corruption in Uganda?
Thank you to you for bringing up this interesting topic on land corruption and issues of land discrimination. Interestingly, I've read the report, especially the chapter on Uganda and the comments in there. And the writer seems to have concentrated probably on two areas of corruption, which they clearly point out, and that is in the area of land acquisition, our processes, and then the entire land administration system and how we offer land services. They point out the fact that almost 2 out of every 5 people end up paying for the land services. But I endeavor to give a bit of quick background on our land administration system and how government has tried to encounter or address the whole issue in the land administration. First of all, when you look at our land administration system, it was adopted from England, and all our laws are emanating from there since the colonial times up to date, and we have not been able to amend most of these laws. And most of these laws are complex, bureaucratic, and of course call for a higher class of technocrats to understand them and first and foremost interpret them to the communities. And because of the language in which they were drafted, you find that even the users sometimes do not understand the intentions of these laws. And so when you look at the land sector, you find that the structures, the institutions of land management and land administration are centralized systems. And government in the year 2007 adopted the decentralization policy to take services nearer the people. And this was in a bid to create much more access to these land services. And in the procedures and processes, government has decentralized the land services. We can say to a certain percentage, creating zonal offices, for example, and computerization of the whole land administration process has enabled to break some of these institutional barriers. And when you go to our land regional land offices, services are delivered in total. You find that those are points of land registration, they are points of land surveying, they are points of physical planning, and they are points where the public can access the land services. But what is the niche there? The cost of land registration is still high because the survey component, which is the highest cost, which has the highest cost, is privatized, meaning that the poor person cannot have their land surveyed. And once you cannot survey your land, it's very difficult to even talk about the subsequent transactions like land registration. So what is happening is that government, in a bid to simplify those processes, we are doing a lot of pilots, of course, with the support of development partners, to ensure that we reach the vulnerable people, including the women, who are the majority users of land, and also who are the majority in our population. The statistics already show that the women are more than men, and the women are youth. The population is youthful, but constituting 50.4% women. So when the report discusses the land acquisition procedures, the law governing land acquisition in Uganda is the law of 1965. And there is no policy on land acquisition. However, we've done a lot of work, not only to review the Land Acquisition Act, but also have been part of that process to draft a land acquisition policy, which will cover not only issues of compensation, but it is also going to cover the livelihood support program. Because when we visited countries like India, we discovered that Uganda's Land Acquisition Act is talking about cash compensation. And in most of our cases, you'd find that the head of the household, following the paternal system, is the man. And therefore, when cases of compensation come up, you find that they are paying everything to the head of the household, leaving the woman and the rest of the family with nothing. So the pricing is done by the Office of the Chief Government Valuer. He or she determines the pricing, and government will go by that price. However, the law provides for access to justice when you are not satisfied with the award given during compensation. And we have tried as much as possible to include in our legal framework the international principles, because most of our infrastructure projects are donor funded, and therefore it is a requirement which they had to push down the throat of government to adopt and include in our land acquisition processes. So you find that the transparency and accountability is better than when we only had the Land Acquisition Act, which was very primitive. We also have the principle in the Constitution of prior, prompt, and adequate compensation. So it's not a closed system as the report tries to put forward, but we have that system and that principle of prompt, adequate compensation. The issue at hand would be, or is, how adequate is adequate? Who determines adequate? Because it is the authority and within the mandate of our Office of the Chief Government Valuer who determines these prices. And therefore, to appeal against that award when the pricing has already been fixed on a compensation, it's very difficult. For example, for a poor woman, do they even know where these offices are? Do they even know what value is for their land? These are issues. And coupled with that, you have low levels of land registration. In Uganda, the attachment of title and not titled land is a new principle in our valuation procedures. Before, in the Land Acquisition Act, if you had a title for your land, even if it is within the same area, you'd get a different value. But with the incorporation of these international principles, Now we adopted those ones, and whether the land is titled or not titled, the value will be the same. And so it's not properly, or it's not true that it is completely a closed system. But what are some of our challenges? We have a different set of challenges that I must put forward, which government has to correct. One of these is our weak legal system. I've told you that we inherited British laws and we have not done much on amendment of these laws. They are very old. And secondly, when you look at the levels of education, sometimes, especially for the vulnerable people, the women, the youth, yeah, they may not have the standards or the qualifications to look into law or hire advocates who are also very, very expensive. And therefore, when the report points out that there's limited transparency, this is because the women, although not taken as homogeneous, but the majority are affected by other factors. Cultures and customs are also a big part in land acquisition process. Just like I've said, paternal families, the head of the household is the man. And therefore, even when it comes to compensation, the woman is second, is not taken at the same level, at par with the rest of the family. And therefore, cultures and customs continue to affect us, even in the land administration and land acquisition processes. But all is not lost. We are doing a lot of reforms. As part of the group, we have finalized the land the acquisition policy. It is before cabinet. This one is going to leverage all the processes, and it is already tabled, and we are waiting for cabinet decision. We have also finalized the Land Valuation Act. Valuation as a department, as a practice, had no regulation, and therefore we are trying to regulate both the practice and also the function of land valuation, so that we have a database across the board where people can go and search for prices in a particular area. This will become public information. We shall post it on our public portals so that people who feel they are dissatisfied with these awards can seek remedies. And working with the civil society in Uganda has also helped us really. We are partnering with a number of civil society organizations who are doing awareness creation on these issues, and they are also giving free legal aid services. This has helped the vulnerable to increase on their awareness of their land rights. And therefore, I would not entirely say the system is closed, but we are opening it up through legal reforms and practice, and also borrowing on some of these international practices until we get there.
Oh, fantastic. Thank you so much, Naomi, for sharing your insider perspective, as well as giving us the milestones of where Uganda has come in terms of land sector reforms, as well as the gaps that probably still exist that you're working on. Let me now turn back to Barbara. Barbara, do you have insights from your work on how the global land crisis has created conditions for discriminatory corruption in the land sector?
Yeah, and of course, with this question, the first question we have to ask ourselves is what exactly is a global land crisis? Because I think that the responses might be very different. Everyone says there is a global land crisis, but we might have different interpretation of that. In my opinion, the global land crisis is a radical degeneration or corruption, if you want to use this term, of the way in which land and natural resources are governed and the impact and the repercussions on people's lives and environment. Land and natural resources have played a fundamental social function in the history of humanity. It is still the case. But at the same time, also it's been the battlefield for power games, for control. As Oxfam, and we work on inequality, we say that land inequality is actually the oldest form of inequality. And if you think about our history, we can all agree on that. But what is dramatically changing right now, and particularly in the last 2 decades? And if you look at the statistics on the increasing land inequality gap, you can see that. Is that the fact that the land, for its finite nature and because of economic and geopolitical events in the past 2 decades, has become more and more a lucrative business. So investments in land as an asset class, what scholars define as financialization of land, gained a lot of traction in these past 2 decades and can be considered also as a response after the financial crisis of the market to mounting risk in conventional stocks. So it really literally became an asset in the market. And to complicate the picture, land also became in these past 2 centuries central to every plans for any nature or land-based carbon removal schemes, for instance, in the climate response. And where these schemes are operated in favor of polluters rather than in favor of people that are actually impacted most by climate change, this also put an unbearable pressure on the world farmland. We have calculated, for instance, that there is simply not enough land in the world to realize all these plan schemes for carbon removal. The cascade effect of this global crisis phenomena on national and subnational level is very rapid. So corrupt mechanisms are faster than the capacity of the governance systems, whatever they are, to adapt and find cautious solutions to deal with them. And it's also true that the suffering of rural and urban majorities also, it seems to be accepted as a sort of collateral damage because of an intrinsic discriminatory vision, not just of people, but also of the systems themselves, like the local land governance systems. These systems are considered not efficient, not adequate to the dominant economic discourse, and even in context, and this we have seen that a lot in our working experience, where foreign investments, for instance, are not present, still the mentality of the dominant model has transformed what used to be a social asset into a speculative business. We see also national actors that are acquiring land through illegal or non-transparent transactions for a short-term or even a long-term benefit, thinking there will be investors coming in. And this is, of course, many times operated through corrupt and discriminatory land transactions. Thanks.
Right, thank you so much, Barbara. Let me turn back to Melusi. Melusi, what factors make it challenging to report corruption in African land sector?
Yeah, I think the whistleblower environment is quite volatile. It's also quite difficult for human rights defenders, given the systems of governance and the type of political figures that are in power. You know, this is pretty much a story relatable in most countries. In the South African context, in fact, one of the organizations that we've worked with, Abahlali Basemjondolo, they are a grassroots-based organization looking at issues of landlessness for shack dwellers and hostel dwellers and other vulnerable groups. And they've had members of their movement assassinated and killed for standing up against wrongdoing and blowing the whistle on corruption. And this is largely because there are certain protections, which is a point of contention currently in South Africa, that should be awarded to whistleblowers. So legislation needs to be revamped, not only in terms of looking at the definition of how a whistleblower is viewed in law. We've conducted a study looking at, for example, the mechanisms that are available and the practices. And pretty much what was realized is that we definitely need to reshape our law in accordance with what's happening currently in the environment, and so that the environment can be safer, not only for activists, but also for whistleblowers. I mean, when you look at the farm communities where we conducted this discriminatory corruption study, those communities have little understanding of whistleblowing, but they even intimidated the farmers or the farms, businesses where they work in. They discourage them from blowing the whistle. In fact, they threaten them with their livelihoods, telling them if they engage with civil society organizations, or should they even complain to government about what's happening to them, they won't have an income. They won't have a place to live at. So that's the environment. There are no proper channels in those rural communities where people can reach out unless organizations such as ourselves go to them and work with other grassroots-based organizations to kind of to reach the people on the ground. So that's at the moment the environment. And the victimization of whistleblowers is not only at that level, at community level, it's right to the top echelons of government. You know, you've even had government officials being targeted, victimized, as well as killed for just standing up against wrongdoing. Thank you.
All right. Thank you so much, Melusi. I'm sorry to hear about some of the terrifying environments for whistleblowers. And I have a follow-up question for you. How can we tell the stories of individuals impacted by discriminatory corruption in a better way?
I think this research that we have done as the region, or at least 7 countries, is a flagship type of research project because it's unique in its stature, right? It chronicles the stories of ordinary people. When Sam started his presentation, he pretty much encapsulated the essence of this work, that we sought to go to the people on the ground and have them tell their story from their perspective, which is quite powerful. In the Corruption Watch case, or the South African case, what we did, we went a little bit further. We wanted to tell wanted it to be an audio story. And we then produced a podcast series because we felt that not only should people hear from the experts and the activists and all the other quote unquote important players in the field, but they should also hear the voices of these marginalized people in these communities, hear it for themselves, how they are being abused, how they're being cheated, and how powerful people and people in cahoots with government officials are getting away with wrongdoing. So I would strongly argue that, you know, it's this type of researchers that reach our level of engagement as activists that are important in terms of storytelling. But for a broader audience, you know, tapping into social media and other multimedia components so that we can reach a broader audiences. And podcasting is one of those ways. Thank you.
Thank you so much, Melusi. Let me now turn back to Naomi. Naomi, when looking at corruption in the land sector, how can your government improve how it considers the needs and impact of discriminated groups like women, indigenous communities, older people, for example?
Thank you so much. Like I have highlighted before, I can't have full screen. Like I have highlighted, there are a number of programs trying to address this. Some are solely by government, while others are in partnership with most of our civil society network. I'm proud to point out that Uganda has one of the very vibrant civil society, which is very active in the land sector. And indeed, we have done a lot of work with civil society. So creation of awareness, when we did the stakeholder mapping exercise to identify our partners, we discovered what civil society can do well. And then we have apportioned those programs and encouraged civil society to work in their mandates to create a lot of awareness. So government will be supported and continuously is supported by civil society. And once civil society is out there, they will give that information which government probably may not have reached out to inform their communities about. But we have also opened the toll-free lines. We have the institution of the Inspectorate of Government. People can run and appeal to those institutions as whistleblowers, but also to report their cases. And these toll-free numbers are on our ministry website, so that anybody who wants to reach the ministry can call on those lines. So they are really helpful because we accumulatively get to know what is happening out there. And the other component is the establishment of land rights centers. This is part of the reforms where we have established different land rights centers where the public can go and access land services. We had to have what we call public portals under the land information system. So you can record your complaint, you can record your questions, you can record your challenges. Coupled with that, we have in the process of establishing mobile land clinics. These are registries where the government goes to the people, government goes to the communities to establish what challenges are within the communities so that they can help and assist free of charge to register people's land. And these mobile clinics are working very well because they are less of bureaucracy. So ensure that the processes step by step are given to the communities. Then we give them the date when the clinic will happen, and you ensure that you get lots of the communities participating in these mobile land clinics. Then there's what we have coped on as massive registration. Still with the support of our development partners, we are doing a lot of massive registration, especially for customary tenure. And we ensure that in these programs, women are part of the whole process, the sensitization and awareness, but also to include them in the family titles. That helps to secure their land rights. And then we also have another program which is checking on our registration procedures. We have what we call open days. We shall go into an area and then we allow the public to access our land information system so they can check on their titles, whether the titles are enough. So we are doing a lot of reforms, both for the technical teams for the technical, there's continuous capacity building on how to handle the public, to take the public as our clients and not like you walk in a bank and not like you remain under your desk and then you expect the public to be the ones rendering this service. So we are changing attitudes and setting a new pace in the whole regime of land administration. But as I pointed out, talking about land acquisition, it has been a big challenge in Uganda, but we have done all that it takes to ensure that all our bills, all our policies are taken to cabinet so that we create more transparency and more accommodative options. Land, for example, and these are the options which are recognized under VGGTs and all other heavy or what we call capital investments, copying from, of course, countries that are ahead of us.
Great. Thank you so much, Naomi. It's great to hear how Uganda is taking these important efforts. Panelists would like to remind you that feel free to answer questions when you can at the Q&A live if you're in a position to, especially on those that are directly. Let's now talk about another aspect of this land corruption that comes about. Sam, can you discuss accountability and information transparency as a solution to corruption in the land sector? In the report, how are accountability and information transparency addressed as a solution to corruption in the land sector?
Yes, thank you. So in the final recommendation section, you'll see there are recommendations on both of these themes. I know Naomi's been talking a lot about a lack of access to information, a lack of understanding, a lack of knowledge. And this was consistent, I think, across all of the countries with the testimonies that were received. In some cases, it was linked to deficiencies in the legal framework. In some cases, it was about information on land systems, land administration, land governance broadly. In some cases, it was talking more about knowledge of individuals' rights or the obligations of duty bearers. But in every country that we looked at, this was, a consistent theme that was coming through. The report itself, it covers 7 countries. There's fairly limited space for us to delve too much into any of these individual topics. But even in putting together that report, I think you can see just the diversity of land systems in Africa, in the countries that we looked at. Things like the land portal database, I think it was basically a third member of the research team when we were putting together some of those framework discussions. Really, really important, really helpful to help us kind of develop out those sections. But I think if, we are struggling as researchers, working in this space, working within this field, then you can only imagine what it's like if you are a person on the ground who's trying to understand the complexities of land governance. Really, really challenging. And we get into this in the recommendation section where we talk about the need to improve access to information, collect data, disaggregated data, particularly important to recognize the different situation of disadvantaged communities. And we talk about it in some specific areas. So for instance, linked to, say, investor obligations, where particular investment actors have made commitments to do a certain thing. Information especially important in that context. On the justice side, on accountability mechanisms, again, this was another common theme in the testimonies that we received. This is one of the dynamics that we explore, specifically looking at the ways in which corruption and discrimination can both impede access to justice. And again, very similar patterns coming through, I think, in every country under review. So quite often people were talking about the weaknesses, the challenges of achieving justice through formal mechanisms, whether that's through, say, the courts, or other mechanisms that have been established sort of locally or nationally. Things around, lack of access to resources, lack of time, delays in complaints mechanisms, really, really common in the testimonies that we received. Also, similar issues arising in the context of informal justice mechanisms, some particular issues around, the application of stereotypes. So there was some really interesting testimonies received about the situation of people living with HIV and AIDS, of women who were expected to resolve, disputes around land within the family, of persons with disabilities, particularly in relation to customary justice mechanisms. Are they able to go see a chief, for instance, where they have a complaint? So we develop out some of these different points, but there's one point on accountability that I think I found particularly interesting, and that's at a slightly higher level. That's really thinking about the ways in which anti-corruption and anti-discrimination laws work when it comes to this question of justice. Because most anti-corruption approaches are perpetrator focused. They look at the abuse of power by those entrusted to wield it. Anti-discrimination law is victim-oriented. It's looking at the individual who has experienced harm for reasons linked to their protected characteristic. Now, this plays out within justice systems because anti-discrimination law takes place principally within the civil and the administrative law, whereas anti-corruption approaches are principally criminal. It's about things like, criminal offences of bribery and things of that nature. But when you look at the way in which these two things interact in systems, you can see some of the challenges with that approach. So, for example, if you're a woman and your husband is ill, you know that your land is at risk. Once your husband dies, whether that's on account of traditional authorities, whether that's because of the competing claims of family members, you're in an extremely difficult situation. And what we see and what previous Transparency International research has found is that individuals, can feel compelled to pay bribes, basically to gain access to rights that should already be available to them. And when you think about the way in which some anti-corruption approaches are going in terms of addressing the individual who goes and seeks to make an illicit payment to, say, someone involved in land administration, you can see there the inherent problem with that approach. One thing that anti-discrimination law does and does well, I think, is it provides specific procedural rules where there is a violation of the right. So a person who is bringing a case will only need to provide prima facie evidence that an act of discrimination has taken place. And at that point, the burden of proof shifts to the other party, the party that is accused of the harmful conduct. What that allows is essentially an opportunity. It creates an inference of discrimination. So it can help to overcome some of those procedural barriers to justice, which so often arise in corruption cases because of the secretive nature of dealings, the fact that most information belongs to the person responsible for the harm. So that's been a really interesting dynamic to explore, and I think there's things to be learned for both anti-discrimination and anti-corruption activists, as well as those working in the land sector, to identify different pathways to justice. And one of the recommendations in this report is on the need for further research in this area. Thank you.
Fantastic. Thank you so much, Sam. Barbara, can you also discuss recommendations related to participation and access to information? What specific measures can be taken to increase participation and access to information regarding land rights in Africa?
Yeah, I think this is very relevant that these recommendations and some measures are also indicated in the report. And these are very delicate and highly debated topics in the land debate. Everyone, again, agrees that participation and access to information is key for a just land governance system. But if you look from the lens of corruption and from the example that Sam just shared, where you have actually people who are supposed to provide information, to protect information, the ones that are actually harming people. So that's really critical. And it's very problematic to adequately address this. For instance, let's look at participation. If participation happens in a unique normative or imposed ideological framework, for instance, a legislative reform, there is a question in the chat about what is the way to go for a legislative reform on land. I think the first element is that shouldn't be the agenda of somebody else, a unique normative model. It should be very open for the participation to be and to serve the purpose of the citizens. Otherwise, it's very easy that it can serve the purpose of legitimizing a certain model or even political corruption. Participation can be tokenistic. So creating a regulatory frameworks with mechanisms in place for effective and permanent negotiation, not consultation on consent seeking, but something that is along the time for having citizens contributing to that. I think this is the first important measure. Something that Naomi mentioned, and I think is very relevant, supporting devolving power to local collectivities. I think this is key. We have a lot of decentralization processes that are real on paper, but not real in practice. And investing into these effective and functioning decentralized institutions, not just on land, but in general. And then also participation from an international NGO perspective also means that citizens have the capacity, the agency, and the opportunity and the space to monitor, to expose conflict of interest, to expose incompatibility of functions, and to expose abuse of power. So creating civic space for these citizens to share their concerns. When we go to information, there are three elements that needs to be taken into consideration. What the information is, because it's not always the same. Who is supposed to disclose the information? And third, what are the mechanisms for accessing information? And I think it requires a multi-scale approach. The regulatory obligations to disclose information shouldn't just be at the national level, either central or local. They have also to comprise more stringent international obligations versus, for instance, corporate actors or financial actors. At the same time, at the national level, the access to information, the disclosure of information shouldn't be only at one level or at one moment in the line. It should go from the very local to the central government. They should also be very broad in scope. We can imagine some perfect legislation on land that integrate access to information. But if there are other legislation, like for instance, on fiscal aspects or on financial flows, let's think about the extractive sectors. So these are very key. Access to information in these areas are also very key to land governance or to abuse of power or to discrimination. So policy coordination in this sense is also very important. Thanks.
Right, thank you so much, Barbara. Let me ask the same question, same vein. How can Uganda improve information in the land governance process to ensure that diverse communities and those encountering techniques, accessibility or technology barriers covered?
Just like my colleagues mentioned, you find that it requires concerted efforts, you know, like we have all argued that land justice is a process. You can have the land institutions in place, but fail to deliver land justice. And when you look at our courts, of course, we need a lot of reforms on the court systems, because the way court works, it's talking about evidence-based processes. You cannot go to court and argue, I have a land which is not titled and you have no document for it. Court would say, show us the evidence. And just like Barbara is pointing out, the reforms must not only focus on land, but the whole entire system of land justice, and then the responsibility of the citizenry. This is also very, very critical. Just like we have acquired some level of political, awareness. When you vote, when you walk to the polls and you vote, people will expect that the politicians are supposed to perform those specific functions that are mandated by law. The same should happen to all these other sectors, to demand. Communities should be able and should be empowered to demand for their land rights. Not only political rights, but land rights. And to us, that should be also critical. The way we are moving the political agenda should be the way we are moving the economic agenda, the land agenda, and all the citizenry should have all these issues on their fingertips. The issue of negotiation, I buy into it, but then this is taken, the issues of equality of genders is not so definite to give a woman, for example, negotiating power with a man, especially on issues of land, because of the culture and discrimination at that level, that a man or a boy is born and inheritance land just passes to them, which is not the case for women, the girls. So you find that the women are expected to buy, to purchase, whereas the boys inherit without paying anything. And this is already inequality in terms of how our attitudes and cultures and customs are. So if you're talking about negotiation, you need and you ought to look at those issues. Then the other component is the monitoring and exposure of the corrupt. This is working, but we have a challenge with our ombudsman, the IGG, that is the Inspectorate of Government, and all the other state-related corruption institutions. The issue of distance, because these institutions still remain at the center and at the region. and walking into them, there's that stigma that the woman will still need to have the guts, the empowerment to walk into those institutions, even if they are at a regional level. The access, I was the other day interviewing cultural institutions and how they perceive these cases, which are brought by women. You'd find that the women walking into an elder's court where they are supposed to report these customary cases either on domestic violence or land rights conflicts, you find that the man will ask the woman so many questions. How did you get that land? Culture. Here, women are not allowed to own land, intimidating them. And they know that for us, we cannot benefit from these cultural institutions. They are determined and set for the men, the male gender. So these are issues that we need to have step-by-step interventions, but also focusing on empowerment. Empowerment of communities to demand for their land rights is critical. I'm not.
Sharon, are you there? Sharon may have, oh, there she is.
I am so sorry. There's a problem with my internet. I do apologize for that. Sorry. So our next round of questions, we want to focus on what next for the panelists. So we want to think about what comes next. Sam, what recommendations have come out of this report for the land governance community?
Brilliant, thank you. Well, I know that we're a bit pushed for time and we'd like to hear some questions, so I'll be very, very brief. Within the report, we set out each of the recommendations under a general principle. Obviously, we've heard today already about the diversity of land systems. In each of these areas, whether you're undertaking reforms, there are new corruption risks, there are new challenges that are bound to come about. And because this is a multi-country study, we decided that it's very difficult to sort of make broad recommendations on very specific topics because ultimately you just don't know how those recommendations will be taken, whether they're going to be effective in the particular national context. So kind of consistent with the do no harm principle, we tried to keep it at a very, very broad level. The recommendations are organized into three headings. So they're addressed to states, they're addressed to the international and regional community, and they're addressed to civil society organizations. So we start with recognition. And obviously this is a report that is focused on discrimination and corruption, exploring those intersections. So recognition starts with recognition of the different situation of different groups, their particular needs, their challenges, their experiences. It also comes down to the recognition of different tenure systems. All of that, is included within that broad heading of recognition. We talk about participation, which I know has, been discussed quite a lot. Accountability, the need to promote rights awareness, to sensitize individuals, to undertake collaboration, and we also recognize the need for further research in this area. I can see already in the chat, some people asking about, the situation in other African countries. We were bound by the scope and limitations of this research. There is a need, I think, for further work at the national level, and the great work of TI chapters like Corruption Watch will be critical in advancing the agenda within the national context. And we've had lots and lots of conversations with chapters about things that are needed in those particular countries and within those particular environments. I'll focus on the second of the recommendations, which is on the need for comprehensive and effective protection. So from the discrimination angle, we at the Equal Rights Trust have done a lot of work with the OHCHR in recent years to distill the core components of comprehensive anti-discrimination legislation. That's multi-ground legislation. It takes a holistic approach, legislation that applies in multiple areas of life. And in the recommendation section, we delve into some of those aspects, talking about the different forms of discrimination, things like segregation, which I think is a particularly important concept within the context of land governance that isn't really relied upon maybe as much as it should be. We also talk about some of the measures needed to proactively promote equality, whether that's positive action measures or equality impact assessment, which links in, I think, to the things that Barbara was discussing in relation to participation. So I'd really recommend that people read those recommendations because they're quite short and they're at quite a high level. Alongside that, the need to mainstream anti-corruption measures in all aspects of land governance. In the Defying Exclusion report that I mentioned earlier, there are some specific points that we elaborate further. So in relation to, say, sensitive whistleblowing and reporting mechanisms, particularly important to address the types of issues that Malusi was discussing, because discriminated groups face unique challenges, not only because they're reporting corruption, but also because they come from marginalized and disadvantaged backgrounds. There are specific safety concerns. This is something that was addressed recently following Defying Exclusion by the UN Special Rapporteur on Human Rights Defenders. So yeah, that's a very, very quick and very high level overview, but I'd really encourage anyone to read through those recommendations because I think there is a lot of potentially useful information in there. Thank you.
Thank you very much. Panelists, we're kindly requesting you to keep your answers brief and short because we are constrained a bit of time. So I'll turn to Malusi now. Malusi, in the case you discussed in South Africa, what are the most urgent actions that government and private sector actors should take to ensure the integrity of land equity schemes?
To echo the sentiment about anti-corruption and land governance is to say that, first of all, there needs to be a recognition that land and corruption are linked, right? It's no longer a debated point, but further to that, we now have evidence that land corruption and discrimination are linked. And it's important to view these things as one, because if we ought to deal with land governance or answering the land question, as they say in South Africa, is that we need to always factor in the high possibility of corruption, which then leads to discrimination, and it then helps us to filter, to factor in these aspects in formulation of laws as well as policies. Moreover, though, there needs to be accountability. The South African government knows, for example, that farm worker equity schemes are a total mess. They've got evidence to this effect. They've done an investigation. However, they don't want to hold the officials accountable. They don't want to hold, more importantly, the farmers, the private players that are involved. So we need law enforcement to actually criminally charge the corrupt parties and those who have violated people's basic rights, particularly the agencies, the Chapter 9 institutions that are meant to safeguard the most vulnerable of our society. And this is work that organizations such as ourselves are currently doing as Corruption Watch, but we do need support from broader society, various actors, so that we actually bring those who are perpetrators of corrupt activities to book.
Great, thank you so much, Malusi. That was very insightful. Let me now turn to Naomi. Naomi, for these recommendations, I would like to understand what measures can Ugandan government take to respond to the findings of this report? Naomi, can you hear me? If you can hear me, please, your mic is muted. Naomi? think in the interest of time, we're going to turn to Barbara for now. We'll get back to Naomi later. Naomi, can you still hear us?
Oh, I lost you, but I'm using my phone.
Oh, all right. That's all right. We understand network issues can be a problem. So my question was, Naomi, in your view, what measures can Ugandan government take to respond to the findings of this report?
A number of measures, but mostly I would depart so much from my colleagues from South Africa and the rest of the globe. It all calls for reforming our policies and laws first and foremost, so that they are speaking to the practical challenges. We cannot live in the past, and therefore it's important as policy drivers to ensure that the policies are up to date, the processes are all incorporated in the laws and very transparent and easy to understand by the communities. I've been to some of these countries where land reforms are taking a new trend. You find that they have gone into simplifying the legal processes to ensure that the general citizenry is assisted. Like I pointed out, the component of legal aid services is still critical, looking at the formal court system, which drives most of our legal agenda, legal regime. We need to have legal aid assistance, especially for the vulnerable who cannot afford even the fees and also the bureaucracy in our formal courts. The other proposal is to ensure that there is continuous mobilization and awareness creation on such topics, especially when you are doing land acquisition projects, so that people form what you call that prior and informed consent. So they are not driven in the dark, but they are able to follow through these processes and have appellate powers and control of these processes. We can have them incorporated into our legal regime so that the public can be protected. The government can put in place such systems that will enable even the poor people, even the indigent, to benefit, and they are not left out of the entire system. This will create a platform and resilience to these communities to be able to protect their own land rights and generally to protect the person, because the constitutional provisions are already in place. No one should be discriminated against. Government cannot take land prior to compensation, but where the checks and balances, implementation issues seem to be very fragile. Timelines within which an applicant can apply for intervention are all issues that can be discussed and put very elaborate into some of our regulations, since we are amending these obsolete laws. This is an opportunity for us to look at that. We cannot continue to dwell on ignorance. We have to watch and we have to be awake, and then we need to create awareness so that the public can defend.
Right. Thank you so much, Naomi, for this important recommendation.
We need to be transparent, and therefore we all have to be there. We all have to support these government institutions. Yeah.
All right, thank you so much, Naomi. That is very important recommendation. Barbara, what are your recommendations moving forward? Please keep it brief because we are a bit constrained of time.
10 seconds, just to build strong collaboration between the people working on global land justice and people working on corruption and discrimination. And when I'm talking about these people, it's not just developer professionals, but also people that are impacted by business. Thanks.
All right, thank you so much for the whole panel. It's been a fantastic conversation. I see that we have been getting a lot of questions, and I'd like to get into that segment now to just answer a few of those questions. We have questions. I think the first question I would like to throw in there, maybe one of the speakers, feel free to just respond if you can. What are the enablers and barriers of effective applications to digital technologies in addressing land corruption in Africa? I can repeat. What are the enablers and barriers to effective applications of digital technologies in addressing land corruption in Africa?
I believe I responded in the chat, so I don't know if it's visible. Also to save time.
Oh, okay. That's great.
Yeah, there's a couple of questions I responded directly.
Okay, then we can move to the next question. What is the impact of land corruption in sustainable land management in Africa?
I think that's also been addressed in the chat. Sorry, I'm very conscious of the amount of time we've got left.
Okay, so let me try to find the ones that have not been responded to in this sector. So someone is asking, I think this is probably for Melusi. I would have a question to Mrs. Kabanda. Please, is there any type of corruption complaint or whistleblower mechanisms at the Ministry of Land in Uganda? Naomi?
I already indicated that we have the Inspectorate of Government institution established by the Constitution. It's a body corporate with a mandate to monitor and oversee the institution of government establishments, and here cases of corruption can be reported. We also have the Anti-Corruption Court, and this ombudsman, the IGG, has the powers to prosecute. And once corruption tendencies have been reported, they will go to what we call the Anti-Corruption Court, and this is where matters of anti-corruption are handled. That is one of the ways, but also we have some other institutions established by State House. There is what we call the State House Anti-Corruption Unit. It also handles whistleblowers arising especially on matters of investment and any other procedures by public officials. So those are some of the institutions that handle corruption.
Great, thank you so much, Naomi. The other question I'm seeing here from Taye is that how can we empower the community to fight from petty to grand corruption? What kind of systems can we create to fight corruption in the land administration sector? Is it pragmatic or to assure that we can fight these corruption activities considering the insufficient government employees and salary? I'm going to throw that to Barbara and Melusi to hear your perspective on that.
Okay, I'll be quick about it. I think it is quite possible to get communities involved to address land corruption because they are the ones who experience these things. It's about equipping them with sufficient knowledge and information on how they can be advocates for change, but also to understand how land corruption manifests So what we found is that, at least in our public education and awareness drives in South Africa, is that people do not actually understand how land manifests. And so it's very helpful then to share, simplified information so that they can use that to lobby and advocate for themselves.
Sorry, Barbara, do you want to add something on that, or are you good?
No, I think we are on time.
All right. So the other question I'm seeing here from Antinette is, what is needed to make anti-corruption measures non-discriminatory? Maybe Sam can answer that, given the institution he works in.
Thank you.
What is needed to make anti-corruption measures more non-discriminatory?
Thank you. I mean, there's a piece, as I said, in the Defying Exclusion report that's talking about sensitive whistleblowing mechanisms. Sorry. Obviously, that's just one small example of a particular mechanism, but I think ultimately it's about recognition. It's about acknowledging, proactively seeking to engage marginalized and disadvantaged communities whenever measures are being adopted. The biggest issue is not so much anti-corruption measures themselves. And in the same way that, anti-discrimination approaches are entirely consistent with anti-corruption measures, it's the fact that these two areas of practice are seen as almost separate species. If you look at the VGGT, I think there are over 20 references to discrimination within the guidelines. There's over 20 references to corruption in the guidelines. Not at one point do these words occur in the same clause. And I think this is something that we've really seen throughout this report. Corruption and discrimination are treated as almost entirely different topics, entirely separate concerns. Whereas, as the research shows, that's not the case. They're inexorably interlinked. You cannot address, in my view, some of the harms that we've identified through this report without addressing both aspects. The big takeaway from that analysis, I think, is that anti-discrimination advocates, for equality advocates, we need to be looking at how we can mainstream anti-corruption measures in our work, and vice versa. Those working on corruption issues need to be engaging with groups that experience discrimination. We've talked a lot about women today, and for good reason. A lot of women experience, multiple challenges in accessing land and enjoying their land rights. But the report covers a wide range of characteristics. And if you look at these issues intersectionally, links to socioeconomic status, to age, older or younger age, religion, ethnicity, all of these different identities can implicate a person's experience. And it's really, really important, I think, that we try to bridge these two communities, or these three communities in relation to the land sector, and try to identify workable solutions drawing on all that expertise. Sorry, too long, but
that's all right. Thank you. That was great, very elaborate and informative, definitely. So thank you so much. This has been a great discussion, and I'm sure that we can go on and on for ages about this conversation, but we do have to wrap up due to time. A big thanks to all our panelists. Thank you so much for joining us here today. We really appreciate your participation and engagement. And a big thanks to all our participants online. It is great to have seen you and engaging with us in the Q&A section. Please feel free to fill our surveys today that has been put on the chat by Neil. Feel free to answer that for us so that we can improve for next time and just get to know your feedback. Also, you can find the report on the website by Land Portal and Transparency International. Thank you so much, everyone. And a final shout out to all our interpreters. It's been a fantastic time. Thank you for making work easier in this webinar, and a very good day, good evening to everybody. Thank you so much for joining the webinar today.
Thank you.
thanks, everyone.
Thank you. Bye. Thank you so much.